So, doctor, currently, what is the criteria of termination of pregnancy?
Uh, the termination of pregnancy in India is governed by
Yes.
the MTP Act. Okay. So for that, I will tell you the brief background of what the thoughts process was in making of this act by the government of India. Before 1971, abortion was completely illegal under Section 312 of the IPC, which was enacted by the colonial government. The only exception was that the woman's life is in danger, and that was allowed as a reason for abortion. In 66, a committee was set up by the government of India headed by Shantilal Shah to review abortion laws. The committee recommended legalizing abortions on various grounds such as rape, contraceptive failure, incest, economic factors, fetal abnormalities, etc. Now, based on this committee's report, in August 1971, the MTP Act was passed, 1971. So it came into force on April 1, 1972, so almost a year later. And it allowed the woman to terminate the pregnancy up to 20 weeks of gestation or 20 weeks of pregnancy, in simple words. It also recognized the failure of contraception as a valid ground for abortion, regardless of the marital status of the woman. That's very important because marital status is attached great importance in our culture, and it is looked down upon if a single woman was to become pregnant. But this kind of destigmatized the single woman getting pregnant, which is rightly so. It was further amended in 2002 to simplify the procedure and to increase the availability of safe abortion services across the country. Okay, it also gave the direction for preparation for having a medical board to decide on termination of pregnancy beyond 20 weeks. The MTP Act was further amended in 2021. Now, this was spearheaded by a doctor called Dr. Nikhil Datar. He's a close friend of mine. He has petitioned the Law Ministry, Supreme Court, etc. And this was amended in 2021 to expand the access to safe and legalized abortions for women. Now they include certain categories of additional categories such as rape victims, minors, women with mental abnormalities, etc. The amendment also removed any upper gestational age for fetal malformations which were incompatible with life, or any condition which endangers the life of the woman or constitutes a grave threat. Now, the important word here is grave, not simply a threat, simple threat. It's not simply a likelihood. It's a grave threat to the woman's or the child's life. And the amendment also reduced the requirement of two medical practitioner opinions up to 20 weeks of gestation. So, what is, for up to 24 weeks of gestation. So, in short, I will tell you what is a nutshell. In a nutshell, the MTP Act has actually, in a way, legalized abortion up to 20 weeks, and that is a broad definition. So, a woman can simply say, or a family, or a woman and her husband partner can say contraceptive failure, and they can get abortion on those grounds. Number two, up to from 20 to 24 weeks, two medical practitioners are required to certify that a woman is safe to undergo abortion, and they are very clear conditions which have been mentioned by the MTP Act, which is incest, rape survivors, women with severe disabilities, physical disability who might not be able to look after the child, but severe disability, mental abnormalities, and women who are in mental institutions getting pregnant by rape or whatever in that scenario. After 24 weeks, if a woman outside of the outer limit of MTP Act wants to procure an abortion, and there are some mitigating factors, then the only way for them to do is to go to the court, who directs the formation of a medical board, or there might be cases in the hospital itself where the case has been referred already to medical board, and a medical board has come to the conclusion that there is grave danger to the life of the woman or the fetus, and they can abort the unborn fetus at any stage if there is serious risk if the pregnancy is continued. Now, that is in a nutshell. So, 20 weeks blanket permission for abortion, simply citing contraceptive failure or family planning allowed. Beyond 24 weeks, any condition which threatens or gravely endangers the life of the mother, allowed. Severe fetal malformations allowed at any stage of pregnancy. So it has simplified the MTP Act for 20 to 24 weeks of pregnancy, as I rightly said, rape, incest, etc. But also not losing sight of the fact that this is one part which is to be executed by doctors, but the second part is the criminal law has to be set in motion in certain uh, uh, pregnancies between 20 to 24 weeks, and that is not to be lost sight of. So that is, in short, the simplified MTP Act which operates in our country at the present moment.
Thank you, Doctor. In fact, you had also elaborated not only the provisions in nutshell, but also the background behind legislating this enactment and how this law actually came into force. Now, you have already touched upon the issue of mental condition and postpartum depression while answering to our queries a while ago. But to throw more light on it, we would like to know that considering the grounds of medical termination taken by the petitioner in this instant case, she suffers from postpartum depression and her mental condition does not permit her to raise another child, and especially the second condition that her husband is the only earning member of their family and they already have two children to take care for, and additionally other family members are also depending on them. Does this also indicate lack of education?
Uh, I will answer your last query first. It
Sure.
may point to a lack of education. Now, there has been no discussion in the judgment about the level of education of this lady,
Mhm.
but she has undergone two pregnancies, and that in itself is an education, I think. Secondly, it is a case of the petitioner woman that her mental condition does not permit her to raise another child. Now, these are mere claims. They have been examined by the medical board specifically.
That is also true.
She was found to be suffering from postpartum depression,
Yeah.
even in the earlier pregnancies. She has been treated, but she has born normal children.
Mhm.
So there is nothing to suggest that this postpartum depression cannot be treated or it is so severe as to cause a grave danger to her life. If the medical conditions would have suggested so, or they had mentioned that the drugs which she is receiving are likely to damage the fetus, then there could have been a cause made out for getting this abortion, but which there are none. The medical board did not find any such severe factors which would outweigh the right of the fetus to live versus being terminated.
Mhm.
Now, other claims, uh, other points of argument, the social factors which have been put forward by the petitioner and or her husband, that her husband is the only earning member of the family, that additional other persons are dependent upon the husband. Lack of education or being a social structure has never stopped our country from overpopulation, really. You can see that. But equally true is the fact that ignorance of the law cannot be used as an excuse. So, not knowing about the outer limits of the act, or knowing to what limit a child can be aborted, or that saying that, my husband is unable to afford because we already have two children living, there are other dependent members. Again, I will not make any loose references to her story because I do not know what is the exact story behind this. I can only gather from what is the Supreme Court ruling on this, judgment on this matter.
Of course,
There has been no
we are
mention.
supposed to stick only, as I mentioned, this only for
Yes, yes. I mean,
educational purpose.
only information we can garner is from the judgment, because otherwise the identity is anonymized.
Yes,
There is
the thing
nothing to
that
suggest. There
such
is
situations could be arising, like it is highlighted because of this judgment or this particular litigant. But such situations could arise in future or could have arisen in past, and it could be in multiple cases. So therefore, we are examining this from the perspective of understanding this law, and because it is very important and pertinent to the society also, it impacts society, it impacts the future generation also. That's why we are trying to kind of understand this law. And in this, to take this further, sorry if I have cut you short, but to take this further, it is also important for our viewers to know how does a fetus grow? When can we say it has life? I am asking this from the point of view of, as much as we think of protecting rights of a woman, can we be oblivious of the rights of an unborn child? So that is, since we are also on the social issues, so this whole aspect also needs to be discussed along with that. You could throw some light on this as well.
First and foremost, I will start with the baseline again. The law is sufficiently wide in scope to allow abortions up to 20 weeks. So it's not as if the right of a woman to either procreate or to abort has been taken away by the state. So we have been liberal, we have advanced in terms of women's rights from what was existing in the past before 1971.
Absolutely.
So, and allowing abortion services at any stage of pregnancy if there is a grave risk to the woman or there are severe fetal malformation. So the law and medical opinion on the subject has taken note of this and has inbuilt those provisions in the law. Now, there are certain medical reasons why termination beyond a number of weeks is risky, which we have already outlined before. I will not touch upon them again. Now, why are we harping on this 20 weeks, 24 weeks, 26 weeks? There is a reason to it. This is called a fetal pain theory. From most of the scientific literature which is currently available, it is said that the fetus can feel pain at 20 weeks or between 20 to 24 weeks. It actually starts feeling pain.
Okay.
Now these studies have been done in the past, in the last 40 or 50 years. But more and more newer evidence is coming up to show that the fetal perception might be as early as 10 to 12 weeks. Now, there is a developing brain and a hypothalamus where the developing cells, which are called neurons, they migrate into that structure. They start gradually differentiating and crystallizing into the brain and the spinal cord as we know it. So how do we know that actually fetus feels the pain? Because the fetus does not answer to us. It cannot respond back. You're assuming. But there are indirect signs as to how we can find out if a person is suffering from any pain or not. For example, grimacing on the face when there is a painful stimulus is seen on ultrasound scans. Or withdrawal of the fetus away from the site of noxious, which is a painful stimuli, is also seen on the ultrasound. Then when there is unusual noise or sudden noise, unexpected events, the baby can perceive what is happening around him, and there is excessive physical movements or there might be lack of physical movements. So either or. So in a way, these are the subtle responses which the scientists need to interpret. So let's say 12 weeks, the pain can feel fetus, but of course we cannot still prove it because, as I said, the fetus cannot talk back to us. But at 20 weeks or more than 20 weeks, there is certainly evidence that the pain can feel, that the fetus can feel the pain of the termination, the procedure, or even intraoperative. There are fetal surgeries which are done nowadays to correct abnormalities. So the fetus is feeling all this. It's simply that we are not.
The right to life for that fetus should start from the 12th week itself.
I agree. But as I said, for concrete lack of evidence at the present moment, 20 weeks is still considered as a reasonable time frame to abort a pregnancy. So as to weigh the balance in favor of both the fetus and the mother, and not create undue burden one upon the other. But let us not lose sight of the fact that fetus is also an independent body which is growing inside the body of the mother. Yes. Especially there are rights of the fetus which are guaranteed under Indian law. Now, first I will tell you what law does not give fetus the independence. Section 21, right to life. For some reason, our constitution has decided that it is part of the mother's metra, as we call it, and becomes an independent life only when the child delivers, which I will accept. But does that mean destroying the child? after 20 weeks. I am not going to, when I say abortions, unwanted pregnancy, I'm only going to talk about pregnancies beyond 20 weeks. I'm not going to talk about what is within the legal purview and what is allowed under the MTP Act. So, what are the other laws which have been made in favor or which can act in favor of the unborn child? Section 13 of the Transfer of Property Act, which states that the moment a child is conceived in utero, it has the rights and rights of the property of the parents.
Yes.
Number two, the Indian Succession Act. If a person dies intestate and the baby is born afterwards, it is considered as the baby was born before the person died and is entitled to the property, especially of his parents or the co-participants as the law goes. The Indian Penal Code 19, 1860 also punishes people who induce an abortion and a woman who hastens her own abortion illegally beyond the stipulated date. So there is a provision for that. There is a Code of Criminal Procedure 1973 which gives right to the unborn child that if a woman is sentenced to death and she is found to be pregnant, most high courts and Supreme Courts, most high courts and the Honorable Apex Court will usually commute the sentence from death to life.
Yeah.
And this is all within the knowledge of legal luminaries. But at the same time, after 20 weeks, the right of a woman cannot be all pervading down to include termination of another life. Right to life does not mean right to take another life. That is one. What is little discussed is the right of the man or the husband partner versus the intending mother.
Well, I was going to, in fact, ask you this question.
We'll discuss upon it a little bit later. But in some countries, like I was talking of, in the UK, US, the right of pregnant animals is higher than a woman who can terminate her pregnancy at will. So isn't that a little bit skewed now? Even hurting or killing a pregnant animal is considered to be a crime in the UK.
Absolutely.
So in short, this is what I feel is the rights of the fetus beyond a certain stage, which should be protected beyond a certain stage, notwithstanding what has been allowed by the legislature in the form of MTP Act.
Since you also mentioned that the medical board it was basically the court also referred to medical board. They have to go to medical board. There is one provision in the act where after 20 weeks, medical board has to come into picture and decide with respect to the termination of pregnancy. Now, the Supreme Court mentioned that AIMS wanted a direction from Supreme Court with respect to stopping of the heartbeat, and the court expressed that it is averse to issuing such a direction of this nature, and of course gave reason for the same. Do you think Supreme Court could have done anything else?
The Supreme First, I will go to the judgment from the two bench judges. Honorable Justice Kohli was averse to giving this order, and she gave a dissenting judgment that her conscience does not allow her to stop the fetal heartbeat. Now, as I said again, fetal heartbeat develops at 8 to 10 weeks. So, are you doing anything different by stopping it at 26 weeks? No. What the interpretation, as I see it, is that when you carry out the procedure for termination of pregnancy, there is a good chance at 26 or 27 weeks that the fetus might be born alive. And in that case, the doctors are faced with a very difficult dilemma of actually taking a life when it has been born alive. Now, a person with true conscience, it's not very easy to decide that if a live child is in front of you, whether you stop the fetal heartbeat by giving fetal medication or poisons or whatever is there in the law, versus whether you put this child in an incubator and allow it to grow up to 38 weeks up into the incubator, and then this child has a good chance of survival. So it's a very difficult dilemma. So when she means stopping the fetal heartbeat, in essence, her interpretation was that if the child is born alive, then will her conscience permit her to allow doctors to terminate that life which has been born already? And that is the underlying gist. Stopping the fetal heartbeat, as I said again, which develops at 8 weeks, has no relevance at 26 weeks. In both instances, you're stopping the heartbeat. But at 8 weeks, when you induce an abortion, the chances of a stillborn are higher. Stillborn as in a dead fetus is much higher than you induce in the later stages of pregnancy, where there is a good chance the fetus might be born alive. And now you are faced with an even bigger moral and problem involving your conscience. So that is what is the underlying thread in the Supreme Court judgment, and rightly so. I think she has interpreted law perfectly, though she might have put it in different words because she's a legal professional. Supreme Court could have just given or quoted two provisions which are enough to decline the petitioner's prayers. One, the MTP Act. So this pregnancy was beyond the purview of the MTP Act, as we are all aware.
Yes.
Number two, absence of fetal defect. And number three, the postpartum depression which the patient claims she was suffering from was amenable to treatment, which she had suffered in the past and had had two successful pregnancies. So, what in effect it means is that they have rigorously followed the MTP Act, which is a good side. But the larger bench has specifically taken Justice Kohli's judgment on record, have considered why her judgment was dissenting, and have upheld that view. And as we rightly know, the larger bench has rejected it. So, in a way, Justice Kohli's orders have been upheld, and hence they are relevant.
Yes.
But two provisions are enough, in my opinion.
Now, since we are on the Supreme Court and the judgment, and Supreme Court in 2022 also, that is last year, had an occasion to deal with similar matter, where it observed that the state must ensure that information regarding reproduction and safe sexual practices is disseminated to all parts of the population. Now, this goes back to our earlier discussion on lack of education also. It also added that in the earlier judgment, last year's judgment, that all segments of society are able to access contraceptives to avoid unintended pregnancies and plan their families. How do you see these measures having impact on society? Do they at all have an impact or not? How do you see society progressing from here? Because this is of last year, and we were already in 2022 at that point of time, with a population of more than 140 crores, and still so many complicated cases still uh, come every day. So, how do you see it, the graph progressing? Is there any progress? Will there be any progress?
Uh, the efforts of the government are certainly showing effect. That's all I will say. Number one, for example, we'll take the case of female feticide, which is a crime. Now, if the government wants to implement certain things, there is a will to implement, which has been clearly seen over the years because they went after the establishments who indulged in such things, the doctors who did the ultrasounds in such cases, the women and the partners who went to such doctors or got their abortions illegally terminated. So now the doctors are under great pressure to adhere to a format, to adhere to the forms, to adhere to the regulations for doing ultrasound scans, etc., etc. It's just an example that if the government wants to enforce something, there is a will to do it, and it is showing desired effect. Female feticide, if you look at the statistics, has severely declined. Rightly so. There is no question about that. But it shows the efforts of the government are bearing fruit. Number two, the population also seems to be going to level off in 2040. You must have read the news. I don't know whether you are aware of the statistics, but because of persistent efforts or because of natural cycles of population growth and decline, we are about to level off in 2040, and in 2070 to 2080 we are going to have a large growing population, like how the Western countries are suffering today. Now, whatever the cause of or effect of the government policies, the information that abortions cannot be conducted, should not be conducted for frivolous reasons beyond 24 weeks has to be disseminated urgently. And that I find missing, which I think can be taken note of, and you know must be disseminated urgently to all the population,
Yes,
really,
because
because this
court,
cutoff is, I'm sorry.
yeah, because court passing guidelines and telling the government or to the executive to do certain things, and that actually reaching to the people, one, secondly, people understanding it, second, and thirdly, people's willingness to obey it. That is also a matter of concern, according to me.
In general, if people are not obeying, then they have to be made to obey certain things for the social fabric to be maintained. As I said again, sufficient leeway has been given up to 20 weeks to have an abortion, irrespective of the reason, citing contraceptive failure, family planning, any other reasons. So sufficient latitude has been given. It's not as if the right of the woman has been taken away. But urgent information is needed to be disseminated at every level, especially the lowest level, to make sure that abortions are completely banned after 20 weeks, or for medical reasons they can be conducted beyond a certain time, but that is not within should not be within the purview of the general population. Okay, you cannot educate the vast masses in one day or 1 month or 1 year, so that is going to take time, but the efforts of the government are bearing fruit. Generally, the level of education literacy has increased. The level of the population, I'm talking about the spiraling of population, has reduced, has slowed down, and it is going to level off. So it means it is having some effect somewhere.
Yes, and
Lastly, it will be interesting.
the fact that such cases are coming up, and then there is so much knowledge being exchanged. It also is a hope for future that such things will be available, that such information will be available. Main thing is that you had mentioned ignorance of law. So the ignorance of law is also because of the lack of information reaching the people. So both the things have to be matched. And I'm sure with such kind of positive approach, it will happen.
Well, the honorable courts can only give a judgment in a particular case,
Yes.
but the effect of that judgment or the implications and ramifications of the same have to be disseminated to the public, and that becomes the job of the government, of the local councils, the local bodies, municipality, etc. And there is a mechanism established already to do that if required. So this case might not reach the masses because it was in the Times of India, other national newspapers. So most of the educated and literate population is aware of what is going on. But if it is to reach the masses who do not read the newspapers, who have no idea of world affairs or politics, that does not mean that they should be marginalized. They should be made aware of the things, basically, is all I'm saying. So, yes, education needs to improve in that respect.
Now, a while ago, you had referred to the father's right. Now, I was going to ask you this question, and this question is that in all this process of termination of pregnancy, etc., we talked about fetus's right. What about the father's right? This I am not asking from or asking you as a doctor, but as an individual, having seen different cultures, different countries, having lived there. Can fathers have say in this at all?
There are multiple facets to this, and definitely it's a very interesting question. And I can express a personal view after looking at what is the practices around the world. Okay, it is not limited to me, but I feel strongly about this issue. The abortion issue is largely devoted to the right of the woman, if you have noticed. That is the
Yes.
center thread which runs across the discussion. There is no right accorded to the fetus, or there is no right accorded to the husband, partner, boyfriend, whosoever it is. So a woman has a right to have the child and induce the father to pay, versus abort the child and divide the husband, partner of all happiness. Now, for example, this woman has argued that the man was her lawfully wedded husband. He already have two children. He is a sole earning member. There are other members to support. For example, if they were in dispute and she was before the courts in some other matter, and she became pregnant from this man, would the man come to the court and claim that I am a single earning member and I have other family members to support? Will the court allow him to escape his responsibilities at that stage? No, it will never do that. So why it's only when the woman says so to the court that my husband is not earning well or he has other members to support? Why does the court enter in this plea? It has to look at both the sides. Number two, can the court direct the woman to continue with the pregnancy despite the man saying that I cannot afford? So the court will say it is the right of the mother to decide whether to continue with the pregnancy or to abort the child. Okay. Now, in 1987, 2001, there have been instances in the United Kingdom where women have gone to court and they wanted their partners to carry on with the pregnancy, but the woman did not accede to the request and they gone to the court, but they lost the cases because the right of the woman became of paramount importance here. Okay. Indian as well as English courts consistently, and indeed in most democratic countries in the world, that a woman's right to abortion cannot be interfered with by her partner, husband, boyfriend. And the woman does not even have to notify the father about her intention to have an abortion. Okay. In 2002, the Chinese attempted a new law where it put the onus equally on the man and the woman if they wish to have an abortion. And that has run into really foul weather. That law is under protest and it is under challenge. We'll keep all these things apart. Okay. Now, father's rights have never been discussed. Is it right to say that the father's conscience, his feelings have no uh, place in society? So, of course, they have, but they have never been considered. They have never been studied. So, woman can legally deprive a man of his right to become a parent, or force him to become one against his will. So, it works in both directions. So, if the man has a morally legitimate interest in having the child, and if the mother misleads the man into believing that she will give the child, and then she aborts, will it be wrong? So, there are so many ethical dilemmas here.
So it
There
is
is no significant clinical studies undertaken to assess how deeply this affects men, but it is nobody's case that it does not. Lastly, when we come to father's rights, we will come to what the courts generally do in cases of child custody and maintenance. Now, again, if the if the woman has a right to continue or abort the pregnancy, by which she can force the man either to pay for the child care or not, depending on whether she wants, notwithstanding the psychological status of the man, most of the courts in most democratic countries, you will agree that the judgments are siding in favor of the women. Mostly custodies in India, almost 97% custody is given to women and only 3 or 4% to the father. Fathers are paying almost maintenance in 95% of the cases, as opposed to the 5% where they are either equal or the wife is earning more. So, if the man is going to pay for a child, if the woman decides to keep the child, then it should be equally important that the man's opinion has an equal value for every person. For example, this particular petitioner took the ground that her husband was already having a burden of looking after two children, other people to look after, etc. So, would that argument hold true if the husband wanted to approach the court and said, I want an abortion?
yeah.
So, it is anybody's guess what the Supreme Court or the honorable courts might have decided. So, I will leave it at that. Now, what I'm trying to say is that man's rights have been overlooked for far too long. And maybe it is time to look at that.
That will also be a very important debate to get into some other time. But
Some other
since
time,
you
yes.
also mentioned about the kind proceedings or the judgments or the law world over, what do you want to say about Roe versus Wade issue, that judgment, and what happened?
The Roe versus Wade is a landmark judgment of the US Supreme Court, delivered in 2022, 24th June 2022. Initially, the US, uh, the various states in the US had allowed great latitude for abortions to be carried out by women, again, unilaterally, up to the late stages of pregnancy. That was original ruling was in 1972. Now, pro-life activists have petitioned the Supreme Court and they have upheld the original law which was existing pre-Wade, pre-Roe versus Wade. That is what was existing before 1971. They have upheld a Mississippi law that all abortions beyond 15 weeks are now deemed illegal. Now, there are some good reasons why the Roe versus Wade stands overturned. The Supreme Court of the US Supreme Court is a very dynamic court. And if they can review petitions, and they have changed their instances in almost 21 out of 34 petitions in the past 20 years, despite their being claimed as constitutional amendments. So that is a fact on record. Now, I feel I have read the arguments pro and against it. The pro arguments are that the woman is the deciding factor. She has complete control over her body. She has complete control over her actions, and nobody can interfere, including the state, including medical evidence. So uh, that was the general idea behind giving the judgment in the first place. That was 1972. Now, Roe versus Wade, why it was overturned, I will tell you a few things. Most of these rights which the women were claiming were coming under the 14th Amendment of the US Constitution.
Mm.
And it was looked at again by the US Supreme Court recently in 2022. And they found that the Supreme Court in 1972 had exceeded its jurisdictional authority. So power to make laws is with the Congress, as is in India as well. It cannot be the role of Supreme Court to substitute their own policy preferences and substitute that for their legislature. So in Roe versus Wade, a right to abort was nowhere mentioned in the Constitution. It was a legal fiction created by the US Supreme Court. Number two, the court misinterpreted the history of abortion practices. They would want us believe that abortion was widespread, easily available in the Victorian English era, but that is not so. More importantly, it gave an unfair direction to the physicians to terminate a pregnancy. And most physicians, not most, all physicians take a Hippocratic oath that we will not give any drug which is fatal to the woman or the life of the child if the woman is carrying a child. And that has been endorsed by the Declaration of the World Medical Association in 1968. That utmost respect for human life from the time of conception. So there is a reason why it has been inbuilt into the Hippocratic Oath and the World Medical Association Charter. The original ruling in Roe versus Wade inferred that woman has great latitude to abort their children in any month of pregnancy. This is saying that, but not in the later months. So it is like saying that it's okay to spread a computer virus, we'll punish you later when the damages become out of control. So there is something akin to that. The primary reason for Roe versus Wade being overturned is to abort, it was to afford greater protection to unborn child. So what I'm trying to say is that the right of the unborn child, which is a collateral life, is being increasingly recognized. It is not to say that it is against women, but it is more pro-life. Then, as I said, the 14th Amendment, the woman's right to terminate her pregnancy was seen to be arising from the 14th Amendment. The 14th Amendment was never intended to create any new rights, but only secure the right and liberties which were already guaranteed by the US Constitution.
Oh.
Now, we come to the social argument that it will impact the couple or the woman socially, economically. She has no resources to look after the children. So will that extend to destroying even toddlers who cannot be looked after by their parents? There is still an healthy adoption system, foster care system. So this argument really does not hold true. So psychological harm is imminent is a very, very shaky ground on which to be carrying out an amendment. And the last thing, which is most important, this trimester framework, first trimester, second trimester, third trimester, they are not found in the US Constitution. The trimester framework has given had given the US Supreme Court self-bestowed power of ex officio medical board with powers to approve or disapprove medical and operative practices throughout the United States. And it is wrong to say that abortion is deep rooted into traditions or that ordered liberty demands the right to destroy one child, which cannot be true. So in 2022, the pro-life activists were much more vociferous in their demands. The US Supreme Court looked at it very closely, and they found that the 14th Amendment did not guarantee any such rights of this taking one's life. No wonder, no question about it that everyone has a right to his own or her own life. But when she's carrying a pregnancy beyond a certain time frame as to what is allowed in the law, then what I'm trying to say is that they cannot exercise sole control over their bodies, and then the state and then the medical evidence has to take precedence over it, is all I wanted to say.
Okay. Thank you, Dr. Kale, for throwing such a in-depth analysis of Roe versus Wade and the judgment which overturned it. So in all, it was a very fruitful discussion which we had today. And I thank you for sharing valuable knowledge. It will be very helpful for our viewers to get the insight into this medical termination issue. And it is very important, not just from the legal or medical perspective, but from the social perspective also, to understand the nuances of these laws. Thank you once again for joining us on Law Charcha.
Rishikesh, thank you for giving me this opportunity to reach a wider platform and to express my thoughts and the legal and the medical views on the subject. So, they are not my personal views, but they have been garnered from a legal framework, from medical laws, medical background as to why we do certain things, why we prefer not doing certain things, and how we are sometimes directed to do the things which our Hippocratic oath does not permit us. So I hope that legal luminaries take note of this when they pass a judgment. And because they are putting great burden on the medical professional, where not indicated, where it is within the law, I have nothing to say. And the woman is well within her right to secure the right to abort or to carry on with the pregnancy up to this intended date. And that is the message I wanted to send out. So thank you for giving me this platform. And it was a very interesting talk for me as well. Thank you.
Thank you for such an open conversation as well. Thank you, sir.